most probably hold in their head some conception regarding the guarantees of liberty expressed in the First Amendment, and should be aware that Congress shall make no law abridging the freedom of speech, or of the press, but some, for whatever reason, tend to conjoin and confuse these two distinct ideas, separated not by the conjunction and, but rather or, a grammatical expression that signifies not a joinder necessarily, as much as an alternative. Some, particularly during a pandemic, times historically associated with fear, confusion and despair, that there remains, even in the current age of information abounding, especially on the Internet, some considerable confusion with respect to the limits of free speech, but most, especially activists, may yet be familiar with the rule reiterated in U.S. v. Schenck, that the most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic, and it does not even protect a man from an injunction against uttering words that may have all the effect of force. One immigrant parson around the turn of the 20th century had retained two licensed attorneys who did not understand that there are actually no rights conferred to anyone by the preamble, and Justice John Marshall Harlan began that bad meeting with the chiding rebuke, passing without extended discussion the suggestion that the particular section of the law had been in derogation of rights secured by the preamble of the Constitution of the United States. Although, therefore, one of the declared objects of the Constitution was to secure the blessings of liberty to all under the sovereign jurisdiction and authority of the United States, no power can be exerted to that end by the United States unless, apart from the preamble, it be found in some express delegation of power or in some power to be properly implied therefrom. And be sure bookmark that notation, unless you are planning a repeat performance of that misguided challenge of a $5 fine in Cambridge, Massachusetts, vowing to take your case all the way to the Supreme Court. Nonetheless, in the landmark case, New York Times v. Sullivan, a case of first impression, brought in libel, the Supreme Court was required to determine for the first time the extent to which the constitutional protections for speech and press limit a state's power to award damages in a libel action brought by a public official against critics of his official conduct. This case brought into vogue and practice the idea of a public figure exemption, determining that if you were a public figure, you could only recover in a libel action if there was a finding of actual malice, concluding that mere negligence or carelessness is not evidence of actual malice or malice in fact, and does not justify an award of exemplary or punitive damages. In this genre of cases, any privilege of a fair comment for expressions of opinion depends on the truth of the facts upon which the comment is based. And so, even when it comes to the press, and even the fake news in a currently contentious politics, there are limits recognized in the courts as to the extent to which the powerful press can go in publishing what the late Philip L. Graham, a former publisher of the Washington Post, had described as the first rough draft of history. The First Amendment guarantee of a free press, separate and distinct from free speech, implies a right to buy the inks and paper necessary for printing newspapers, as the Supreme Court had observed in Minneapolis Star and Tribune Company v. Minneapolis Commissioner of Revenue. And still, observing some close nexus to free speech, that court had noted how the right to speak would be largely ineffective if it did not include the right to engage in financial transactions that are the incidents of its exercise, just as the Second Amendment right to keep and bear arms necessarily implies a corresponding right to obtain the bullets necessary to use them, as the Ninth Circuit had recently observed in Jackson v. City and County of San Francisco. Essentially, one fundamental difference between free speech and freedom of the press is that a free press is most often a business, with attendant business requirements, including the rational objectives of a profit-maximizing entity. Generally, in business, notwithstanding a privacy interest connected to sensitive, medical information, for instance, a disability-related inquiry or medical examination of an employee may be permissible where that investigation is job-related and consistent with business necessity when an employer has a reasonable belief, based on objective evidence, Even harassment only becomes unlawful where 1. Enduring the offensive conduct becomes a condition of continued employment, or 2. The conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. Passing these nuances in legal terms of art for legal practitioners, the Supreme Court recognized what is often described as a prudential rule, that scrutiny of employer decisions that cause an adverse impact is warranted, as employers must persuade fact-finders that their choices are reasonable, and that this will sometimes affect the way employers do business with their employees. First-year law students, completing a semester in torts, become intimately familiar with the reasonableness standards, and, as the court had observed in Kelly v. Callaway, even a soldier must follow common sense. And, departing the paradigm of free speech and the free press, one recent case examines press coverage during the most recent COVID-19 pandemic, where many news sources, where many turn to for answers, while forced by mandates to remain at home, even if retreating further in isolation to echo chambers aligned with their ideological viewpoints and political allegiances, contributing to record-breaking profits for cable network news and even newspaper publications, exceeding even revenue from political advertising for some during the 2020 presidential elections. One recently filed case in Richmond is taking a deep dive not into the rights to a free press as much as into the heightened duties of the news business for its invited patrons and loyal customers.
Even in the news business, a party must show that conduct fell below an objective standard of reasonableness, and the proper measure remains simply reasonableness under prevailing professional norms as articulated by the Supreme Court in Strickland v. Washington. While generally a defendant is entitled to a rebuttable presumption of reasonableness, under this deferential standard, a party can rebut this presumption only by demonstrating that his or her conduct is unreasonable, as stated by the Seventh Circuit in U.S. v. Mike. Under this business approach to the news business, where presumptive reasonableness is challenged by probative evidence of unreasonableness, the challenge must be met by some evidence of reasonableness. If evidence of reasonableness is sufficient to make the question fairly debatable, the conduct must be sustained. If not, the evidence of unreasonableness defeats the presumption of reasonableness, and the ordinance cannot be sustained.
While there is no liability for harm resulting from dangerous conditions of which defendants do not know, and which a reasonable inspection would not have discovered, or from conditions from which no unreasonable risk was to be anticipated, and the plaintiff in Webb v. Washington Post, filed in the Circuit Court for the City of Richmond, is presenting the argument that, with regard to news coverage during the recent pandemic, a reasonable jury could find that defendants breached their duty of care for various reasons. In the Commonwealth of Virginia, the general standard or duty is the duty of reasonable care, that is, the duty to avoid negligent conduct, and this general duty is owed to those within reach of a defendant's conduct. And courts employ a totality of known circumstances approach, based on a long but non-exhaustive list of factors, to determine whether speech unreasonably alters participation. How much did news content providers like the Washington Post and WJLA, the Washington ABC affiliate, know about the novel coronavirus? When did they know it, and did they actively work to suppress the truth? No reasonable person would expect this story to ever appear in the press, and you look like an intelligent person.
This message was approved by Major Mike Webb. Honest. This has been a Filmways presentation, darling.
And y'all come back now. Yeah.